Hi. I didn't expect anyone here. How are you? I was just going to talk to myself because I can't believe what I'm reading. I'm not an attorney, so we're going to just start with that. I'm not an attorney. But I was reading this motion. Have you all seen it? There is a motion by Karen Reed's defense to dismiss two of her charges, and I'm not an attorney. I don't really know how to read these motions very well other than as a layperson. But my first thought when I read it was like, so the story is there was a mistrial. Notes were sent to the judge. The judge sends notes back to the jury for Karen Reed. Say, you guys got to try and work this out. It's very expensive to retry the case, blah, blah, blah. Judge Bev sends it back. Like an attorney wrote the note to the judge. It was very well written. The judge says, okay, we think they did their due diligence. No one asked for a poll. Judge calls a mistrial. No one asked for a poll. Someone on another, I guess it's on the court TV threads, when I said that, they're like, well, the judge didn't allow a poll. So the first thing I looked up was, well, why didn't she allow a poll? Like, I'm a fair person. I don't know Massachusetts law. I barely know Florida. So this is what I found in the Criminal Procedure Rule 27 of a verdict. And that's where a verdict is taken into consideration. Remember, she called a mistrial. So the verdict shall be unanimous. We all know that. It shall be general verdict returned by the jury to the judge in open court. The jury shall file a verdict slip with the court. No verdict slip was filed. No verdict was read because there was no unanimous verdict. These were all individual charges, right? They weren't all like one had to do with the other. If there were two or more offenses or defendants offenses, which there were more than two offenses, or defendants try together, the jury may, with consent of the judge, at any time during the deliberations, return or be required by the judge to return a verdict or verdicts with respect to the defendant or charges as to which verdict has been reached. At no time have we heard that any verdict was reached. That's not proper English. At no time was the jury that we know of as lay people watching the Karen Reed jury deliberation was a verdict reached. Is that right? Were they able to reach a verdict? I'm so Dutch. Were they able to reach a verdict? We have not heard that at all, but this is what it says. This is Massachusetts.gov. Rules of Criminal Procedure. Criminal Procedure Rule 27 verdict. So if there are two or more offenses or defendants tried together, so there's more than two offenses because there were three charges, the jury may, with consent of the judge, at any time during its deliberations, return or be required by the judge to return a verdict or verdicts. In this case, it would be verdicts with respect to the defendants or charges as to which a verdict has been reached. And thereafter, the jury may, in the discretion of the judge, resume deliberation. We know that we were told no verdict could be reached. Now, there's discussion about the verdict form, and the verdict form was very obscure, and the verdict form was blah, blah. They've been using that verdict form forever. The judge may declare a mistrial as to any charges upon which the jury cannot agree upon a verdict. So there could have been a mistrial on 1, 2, or 3, provided, however, that the judge may first require the jury to return verdicts on those charges upon which the jury can agree. So if the jury, which these informants, they're known as B and C. I think he has them, Alan Jackson has them, yes. He has them informant B and C. I'm just a layperson. I follow sports, right? So if your guys are back in the huddle working out a plan and they can't come up with a plan, and the coach, who's the foreman, doesn't tell the referee, we have no plan, we can't do anything. That's what's on the note to the judge, and none of the other jurors step up while they're still in the courtroom. Why are we even discussing this? I mean, I guess they have to try. But it literally says they could have mistried on one of the verdicts and then found guilty on the other verdicts. She mistried, she is in Bev, the judge, mistried on all the charges. Like all the charges. This so reminds me of Charlie Adelson's, the alternate number 15, who lost his mind because he could not be on the primary jury, on the jury of 12, and he was dismissed as an alternate. If we all recall, it was a day. So he's out, and he's like, you should have seen the look on his face. He like lost his mind. Anyway, some jurors, according to Alan Jackson and this team, show up and start calling the defense side immediately after the mistrial and say, hey, this was 12-0 on the first two charges, so now we're going to leap to double jeopardy. So my husband's a big sports guy. And say FSU is playing Clemson at the end of the year, and Clemson loses to Alabama. My husband will immediately leap. If he beats Clemson, then he should have been able to beat Alabama. Instead of like each game is an individual game and you can't leap forward. Like he leapfrogs games and be like, well, if we beat this team, then we should be in this position. That's not how it works. I don't know why he does it. It probably just irritate me at this point. But it's not how it works. You don't get to leapfrog because the whole trial, all three charges, suffered a mistrial. Not just one charge or two charges or three. But she could have, at her discretion, done something else. That's not what happened. That is not what happened. And they're trying to go backwards now. So here's the motion, which, let's see, make it bigger. Okay, so this is where you know an attorney likes his own words. So it starts off with, now comes defendant Karen Reed, which you gotta love it. By and through undersigned counsel. And he talks about the Declaration of Rights, the United States Constitution, the 5th, 6th, and 14th Amendment. If we all remember Conjunction Junction, we're like Schoolhouse Rock. The ancient right to a jury is no mere procedural formality. And he's like very strong on the Federalist, number 13. Like he's bringing up all of every historical document that he can find, Parliament, the Crown. I mean, it's rich. It's rich to start with. Then it's like, it follows a jury acquittal is entitled to the utmost respect in our criminal justice. The double jeopardy clause provides that no person shall be subject to the same offense to be twice put in the jeopardy of life or limb. Bluford v. Arkansas, which is great, but there was a mistrial. No one asked for a polling of the jury. The judge would have had to consent. The judge did not consent, but no one asked. Does anyone beside me remember the fact that Karen Reed's defense was like, whoop, whoop, we have a mistrial, whoop, whoop. And now all of a sudden they're like, now you can't try us on those two clauses. Come on. That's funny. That is funny. But you get the idea of the leapfrogging games. No one polled a jury. Neither attorney motioned to poll the jury because she wasn't going to do it. Because it was private and they're going back to private citizens and she probably didn't want them harassed. But they're going off of the jury note by the foreman saying, hey, Bev, we can't come to any agreement. We've been back. We've been forth. We took the extra weekend. Prosecution says, I don't think they've done their due diligence. Bev says they did. Bev calls a mistrial. No one polled the jury. You can't now say, Well, B and C came out of the jury room and is now saying, well, you have to accept what they said. It doesn't work that way. I mean, you could try. You can create nonsense. You can hope the bloggers come out and the free Karen Read people come out of nowhere. But that's not how it works. And it's certainly not how it works as I read it. I'm not a Massachusetts attorney or any attorney, but I can read. The clause guarantees that the state shall not be permitted to make repeated attempts to convict the accused, thereby subjecting her to embarrassment, expense, and ordeal, and compelling her to live in a continued state of anxiety and insecurity. That's what happens when you roll over your boyfriend, as well as enhancing the possibility that even though innocent, she may be found guilty. Perhaps the most fundamental rule in the history of double jeopardy jurisprudence has been that the verdict of acquittal could not be reviewed on error or otherwise without putting a defendant twice in jeopardy and thereby violating the Constitution. Here, the very day after a mistrial was declared, here's where it comes out, undersigned counsel began reviewing unsolicited communications from 3 of the 12 deliberating jurors, indicating in no uncertain terms that the jury had a firm 12-0 agreement that Ms. Reed was not guilty of 2 of the 3 charges against her, including the charge of murder in the second degree. Given the central importance that those acquittals have held in our criminal justice system for 100 years, the defense respectfully submits that the jury's unanimous agreement precludes reprosecution. This is such a shot in the blindness of the black hole. Ms. Reed on counts 1 and 3 and mandates dismissal. Come on. This is no different than alternate number 15, was alternate number 3, juror number 15 and Charlie Adam coming back and saying they had a group text. They were talking amongst themselves. Alternatively, to the extent that the court believes further factual development is required, the defense respectfully requests that a post-verdict inquiry be held on the issue that the court authorized defense counsel to seek additional proof from the jurors regarding their having unanimously acquitted the defendant of 2 or 3 charges. Judge comes back, denied. And this is not going to happen. It's not. So go back to Massachusetts. Poll of the jury. Special questions. The trial judge may submit special questions to the jury. Didn't happen. When a verdict is returned and before the verdict is recorded, there was no verdict returned, the jury may be polled in the discretion of the judge. If after the poll there is not a unanimous occurrence, the jury may redirect to retire for further deliberations. So if they had said, we got a verdict on 1 and 3, we're 12 and 0, she polls them, they come back 9 and 3, then they send them back. But that's probably just a shit show too. The rule is patterned after Rule 31 of the Federal Rules of Criminal Procedure. Substantially, it reflects current Massachusetts practice as embodied in the common law and statute. The subdivision requires that the verdict be unanimous. This is consistent with Fed R. Crim P 31A. Subdivision permits a jury in a multi-defendant or multi-offenses case with the consent of the court to return a verdict at any time during their deliberations with respect to charges or defendants as to which verdict has been reached. They didn't come back with any verdict reached, not even 12 and 0. So is that on the foreman? Is that on the foreman then? The rule also permits the court to require the return of such verdicts before the jury has reached a verdict as to all the defendants or charges. In either case, if the court directs the jury is to continue its deliberations after rendering the verdicts under this subdivision, to the extent that this rule permits the jury to return such verdicts without having reached a decision on all charges or defendants. So basically, what I'm hearing, and you guys probably know more than I do, they said, hey, Bev, we got verdict on 1 and 3, but not 2. What do you want us to do? She could redirect and say, go back and work on 2. Thanks for letting me know about 1 and 3. But that's not what happened. And no time do we know that the foreman came out and said, we got a verdict at all. This rule also provides that the court may declare a mistrial in cases where the jury is unable to reach a verdict. However, it must receive and record the verdicts which jury can agree upon. But to our knowledge, there are none. Subdivision does not prohibit retrial of those defendants as to whom the jury is unable to reach a verdict. This is consistent with Fed R Crime P31B, which provides that in cases of multiple defendants, which we don't have, disagreement as to one or more has no effect upon the verdict as to any other defendant. Such defendant may be retried, which is how it worked with Catherine Magbanua and Siegfried. It has long been settled that jeopardy does not attach where the jury is discharged. Let's highlight that, Patricia. After inability to reach a verdict. United States v. Perez. Thames versus Commonwealth. It is within the discretion of the court to declare a mistrial where there is manifest necessity. United States v. Perez, super at 580. Unless such manifest necessity exists, a second prosecution will be barred by the double jeopardy clause. Since Perez, it has been held that where the jury has been able to agree upon a verdict, the declaration of a mistrial is a classic example of manifest necessity. Thus, the defendant may be retried without twice being placed in double jeopardy. I'm not an attorney, but it's pretty freaking clear. Bev's going to deny it. Here's the background of the nonsense. There's no point. The following day, on July 2nd, 2024, Attorney Jackson was contacted by a juror, call her Juror A, who stated that he wished Ed to inform him of their true results. God, why do these jurors want to be so much a part of the story? According to Jury A, the jury unanimously agreed that Karen Reed is not guilty of count 1. Jury A was emphatic that count 1, second-degree murder, was off the table, and that all 12 of the jurors were in agreement that she was not guilty of such a crime. The jury was unanimously agreed that Karen Reed is not guilty of count 3, leaving the scene. Another day, July 3rd, Yannetti was contacted by two different individuals, B and C, who received information about two distinct jurors, Juror B and Juror C, both of whom were part of the deliberating. Yannetti, informant B, sent attorney Yannetti a screenshot, of course, she received from someone, intermediary B, God, of text messages that intermediary B had received from Juror B, in that the screenshot Juror B texted the following, come on, it was not guilty on second degree and split in half for the second charge. I thought the prosecution didn't prove its case. No one thought she hit him on purpose or even that she hit him on purpose at all. Informant C had been in contact with another C who's a coworker and friend of C and joined a Zoom meeting during which C, oh yeah, this is rich. I'm sure everybody and their brother is going to just jump through hoops to offset charges 1 and 3. It's crazy. The argument is, as if we haven't heard enough, the jurors' unanimous conclusion that Ms. Reed is not guilty on counts 1 and 3 constitutes an acquittal. Does it? What constitutes an acquittal is not controlled by the form of the action. Rather, the court must determine whether the action actually represents a resolution, correct or not, of some of all factual elements of the defense. The mere presence, here it goes, of having a check mark on a form is not dispositive, except that check mark is recorded and placed on the record. I'm sure that he would challenge if that check mark wasn't recorded properly in an appeal. Here, the attached affidavits by attorneys Jackson and Yannetti reflect the statements by the 3 delivering jurors that the jury had reached a final unanimous conclusion. There was nothing tentative about their statements. They were sure. They were so sure. Reflecting a text message, it was not guilty on second degree. No one thought she hit him on purpose or even that she hit him on purpose. No consideration of murder, too. Should have been acquitted on that count. The Supreme Court's decision in Bluford, which is the first case, which I have back here is Bluford. Somewhere up here is Bluford. Bluford. Where is it? Bluford is not the contractee. There, a juror had reported during deliberations that the jury was unanimous against the charges of capital murder and first-degree murder, but split on manslaughter. The court sent the jury back to continue. When the jury remained unable to reach a verdict, declared a mistrial. The Supreme Court rejected the defendant's argument that double jeopardy clause prohibited re-prosecution for capital and first-degree murder. In doing so, the court relied heavily on the lack of finality of the juror's report. Why would he use this? The jury deliberation has not concluded, and it went back to the jury to deliberate further. Here, by contrast, the juror's statements reflect a final determination that persisted through the end of deliberations. Why didn't they stand up and say it's wrong? Why didn't they stand up and say the foreman's incorrect? We have it. We have it. We have it, Judge. Everyone went home? Didn't everybody just go home? Re-prosecution is independently barred because there's no manifest necessity to declare mistrial on counts. The double jeopardy clause affords a criminal defendant a valued right to have a trial completed by a particular tribunal. Thus, where a mistrial is entered without the defendant's request or consent, retrial is impermissible unless there's a necessity of the mistrial. Here, Ms. Reed did not consent. They were celebrating a mistrial. If we all remember, they were celebrating. Hugs and kisses, everybody. Everybody was celebrating. Allen Jackson Affidavit, also Commonwealth v. Edwards, rejecting argument that the defendant consented to the declaration of a mistrial because he did not object when the judge ordered the case dismissed. Of course. Why didn't he object? Absent the defendant's consent, state and federal double jeopardy protections bar as a general rule retrial of a defendant whose initial trial ends without conviction. So he's saying the judge declares a mistrial, but Reed didn't consent to a mistrial, so now Reed should not be retried. The rule is rooted in the importance of a defendant being able to once and for all to conclude her confrontation with society through the verdict of a tribunal she might believe to be favorably disposed to her fate. Accordingly, the heavy burden of establishing manifest necessity to justify a mistrial is exclusively on the Commonwealth. Before a court declares a mistrial for manifest necessity, counsel must have been given full opportunity to be heard. The trial judge must have given careful considerations to alternatives to a mistrial. So now they're complaining about the mistrial. I remember, call me crazy, Aunt Bev asked both sides why not have the jury go back and continue more. They came to the conclusion that the jury couldn't do any more than that they've already done, and so a mistrial was occurred. No one at that point asked to poll the jury. Here, the defense respectfully submits that the lack of opportunity to be heard alone dispositive. Upon receiving a jury note, the court declared a mistrial and excused the jury without consulting counsel. That's not true, because I watched it. She said, "Do you have anything to the prosecution? I'd like to hear from you first. Do you have anything from the defense? And what has stopped Allen Jackson or Yannetti from standing up and saying, I object at any point during this trial? The action was sudden, brief, and unexpected. Really? It was unexpected, Allen? You had all weekend. Neither proceeded nor accompanied by discussion with counsel. He had a weekend. He knew. The record is independently lacking a second prong. Oh, there's more. As it reflects no careful consideration or of alternatives to a mistrial. What are the alternatives? Here, there was one obvious alternative, to simply ask the jury to specify the charge on which it was deadlocked. Had the court done so, and the jury articulated its verdict consistent with the statements of Juror A, B, and C, and double jeopardy would have been clear and decisive. Indeed, with virtual unanimity, the case have applied collateral estoppel to bar the government from relitigating a question of fact that was determined in defendant's favor by a partial verdict. But unless she read something that we don't all know about, I don't know that the jury's note to Bev implied that any verdict was reached. The Supreme Judicial Court's holding in Commonwealth v. Roth that courts should not request partial verdicts or lesser included offenses charged in a single count does not pertain. Well, of course, there's a court case that says you shouldn't do it. Now he's saying you should do it. Inquiry concerning partial verdicts on lesser included offenses that have not been separately charged carries a significant potential for coercion. To consider giving the jury now options for a verdict in the form of partial verdicts on lesser included offenses under Arkansas law, the jury's options were limited to two: either convict on one of the offenses or acquit on all. As you recall, AJ wanted the form changed so it would be more clear, and they still didn't come back. Such inquiry, in effect, implies that the jury should consider conviction on the lesser count, which is why I read that the Supreme Court of Massachusetts wrote the verdict form the way they did was so that it wouldn't have that, because she could have been not guilty if they didn't circle the right circle. No similar danger is present where, as here, the jury was asked to return 3 separate verdicts on 3 separate counts. In the circumstances where the jury reports a deadlock without specifying the count on which it is reached an impasse, it is straightforward, and the defense contends constitutionally required, capital C, follow-up to ask whether the deadlock relates to some as opposed to all counts. Indeed, the Supreme Judicial Court has explicitly stated where a complaint or an indictment in multiple counts charges multiple crimes, a jury general verdict could be returned as one of the counts, but in the end, they leave it up to the judge. Alternatively, the defense is least entitled to conduct a post-verdict inquiry, which you absolutely will never see because it's been a week and a party. We've had a party. We've celebrated the Constitution, the birth of the nation. It's not happening. How are you all doing? Trial coverage behind a paywall. Let me go back. I'm missing something. Leslie's working. The motion is BS, but it's still fun to read. I hope Judge Granson isn't ready for this to be over. That's funny. Anyone watching Baldwin hearing? They're on lunch still. I was watching it earlier. Oh my. Is it that could not reach verdict on the initial charge, but not the second charges that were lesser included? That's what's going on here? No. What's going on here is there was 3 charges. They were separate. They weren't lesser included. They weren't included. They were 3 distinctly separate charges. Jury sends a note to judge. Judge says, we can't reach a verdict. We've been doing this for 10 minutes. We can't do it. Okay. We're dug in. She sends them back. Give them 45 more minutes. That's great. They want to wait the weekend. They come back. Note to the judge, we still can't do it. Unless there was portion of the note that we didn't get to see as the public, it does not say anywhere in the note from the foreman to the judge that any verdict was reached on any of the individual charges. Reed's defense is saying, whoa, we got a text message, which to me is just still, like, I'm a boomer. I'm not a boomer, but whatever generation I am, I think X. I find that hilarious. This is like someone's life's on the line. Someone died in the road, frozen to death, with his head basically crushed in, and we're all talking about a text message. That's just not a reliable source of communication to me, but it is. So text messages are sent from some of the jurors, and then they had a Zoom and they had a group text, and they're like, no, it needs to be this way. And because the judge didn't give the defense an opportunity to accept the mistrial, which is a new one, hadn't heard that one. Although Bev did say to the prosecution, what are your words? What do you say? Did they do their due diligence when they were doing their deliberation? Prosecution says, no, they weren't. Defense says, it looked pretty good to me. But no, really, like, mistrial, do we consent? But did he object to the mistrial? That's why it's so important to my little law and order degree that I have, that these attorneys object for the record, because things like this come up. And if maybe Alan Jackson, Yannetti, had objected to the mistrial, maybe they would have a leg to stand on. Maybe they could have said, hey, judge, maybe we should poll the jurors in public. And then Bev would have been like, hey, we're not doing that because that could be coercion, which is part of this document. You don't want the jury to be coerced. It's going to be denied, but it's just going to create more hullabaloo for Karen Reed and her people. But I don't see them. Her numbers aren't going up on her defense fund right now, so maybe that's why they're doing this. The defendant asked for the court to authorize undersigned counsel to initiate contact for the sole purpose of asking each juror whether the jury had unanimously agreed that the defendant was not guilty on counts 1 and 3. If you recall, last November, we had some sort of similar kind of situation with Charlie Adelson. Juror number 15, we all believe is who it was. He's the alternate number 3, threw a fit saying he wasn't part of a group text. They could have been deliberating without him. They set a motion, like Rashbaum was like, hey, we need to talk to every juror, and Everett denied it. Stephen Everett denied it clearly. I mean, it wasn't even a thing. So exactly. No one polled the jury. They've been released, and no one knows what they've seen on the news now. It's over. It's over. It's July 8th. He didn't do anything on July 5th. He didn't do anything on the other days. For the foregoing reasons, Ms. Reed respectfully requests the Honorable Court issue an order dismissing counts 1 and 3. And this, my friends, will likely have cost her $55 million just in having them write this brief. I mean, can you imagine the cost of this? Martin Weinberg, Alan Jackson, Pro Hack Vice, Esquire. The Supreme Court, what I missed, the Supreme Court has held that because of the importance of the issue, juror bias is legitimate subject for post-victory inquiry. Well, you're saying that you can't. He's literally throwing and conflating everything in this brief. He's conflating double jeopardy with jury post-verdict bias, with not having a motion read, with having a mistrial not consented to by the defendant. I mean, it's a lot. I think that what they threw together was this brief. How many pages? 17. But most of it's blank, right? Most of it blank. Yeah. Oh, here's the affidavits. Yannetti's affidavit, his says, informant B sent a screenshot, so you know it must be true, have received from someone, intermediary B, because that's, courts love that intermediary B has received from juror B. In that screenshot, B texted the following to B: it was not guilty on second degree. When the judge sent us back with that Hernandez thing to look at the other side, which is their, you better please work it out because this is expensive, turned into a bully match. I thought the prosecution didn't prove the case. No one thought she hit him on purpose, even though he spelled it wrong, even thought She hit him on purpose. They gave us free counseling forms when we left. Based on the first name of Juror B given to informant B, I believe I'm able to positively identify, he's not even sure, which juror she was. It was confirmed that she was a deliberating juror. He's not even sure. Are you freaking serious? On July 3, informant C contacted me that she personally knows Juror C as they used to work together. I should have just started with this. Informant C and Juror C also have a mutual friend, C, who's a current coworker and friend. C told me that she had been posting something about Karen Reed on Facebook. She told me, it's she or he, believes that the post led C to text him or her and inform her that C was a deliberating juror. Informant C told me she thereafter reached out to Juror C via text message and discussed their experience as a juror in general terms. They discussed what an exhausting experience it was, and that C was relieved it was over. C told C that C would be participating in a Zoom meeting with a number of friends to discuss it. Today, C sent me 3 screenshots of a text message exchange. Informant C told me that C was reporting to him, her, during this exchange about C had revealed during Zoom. It's a Zoom! Oh my God. No consideration for murder, 2. Manslaughter started polling at 6-6, then was deadlocked. 4 no, 8 yes. Manslaughter started, okay. So it started at 6 and 2 people moved. She was very consistent in the fact that they could only consider things that were admitted into evidence, obviously. Ultimately, she voted no because the cause of death was twofold, hypothermia and head injury, of which he was convinced that the vehicle did not cause both. Well, it did, because he wouldn't have been dying of hypothermia if his head hadn't been crushed by a car. The whole jury felt very intimidated by Higgins' presence at the end. She not sure what she going to do. She's going to lay low for a couple days and see where it takes. Hasn't ruled out anything. The jurors all have a group text going. Interesting. If it was no consideration of murder too, shouldn't she have been acquitted? Informant C is not an attorney. And then hung on the remaining, goes back to the jury slip that was all confusing. C says, she should have been acquitted, I agree. Yes, the remaining charges were that they were hung on and that the instruction paper was confusing. They've been using the same paper forever. What a great experience for him, her. Amazing that they let the Alberta in the last day. She felt very honored to be part of it. She was redacted physical description. Everybody else was from a professional walk of life. They all got along and never heated. They agreed to disagree and respect. That's the way it should be. Knew it was an intelligent jury that would be studying this case in law programs for years to come. How not to investigate and try a case. If they all agreed on no for murder 2, they should make that clear to the DA and the court. It's basically a case of double jeopardy. So informant C is the one who's decided that it's double jeopardy. So why don't we all just jump? Based on the description of C, I know who she is. Alan Jackson. He was contacted by A based on the conversation with A and the juror's description, where she was seated and certain identifying information, occupation and name, disclosed during the voir dire process. I was able to positively identify which juror. Juror A told me she was seeing inaccurate reports about the split among the jurors related to the mistrial. Juror A stated she was wished to be respectful of the privacy of the deliberation. A indicated she believes it's important to disclose such results because she believes, well, let's change the rules, that those results significantly impact Ms. Reed's rights. A told me that the result of the deliberation was that the jury unanimously agreed she's not guilty on 1 Juror A was emphatic that count 1, second-degree murder, was off the table, and then all 12 jurors were in agreement. Juror A told me that shortly following the determination of 1, jury was unanimously agreed that count 3. That contradicts B and C's story, but okay. On July 1, when the jury presented a note to the court, all counsel were ordered to the courtroom. The note was not presented to counsel for review. Rather, the court indicated the jury was at an impasse. Once the jury was seated, the court then read the jury note verbatim in open court without providing any opportunity for the defense counsel to be heard. The court declared mistrial and excused the jury. That is not. I mean, he skipped like a couple days. Neither Ms. Reed nor her counsel consented to the entry of a mistrial. But did you object? Did you stand there, Alan Jackson, and object? Just a girl sitting here trying to figure you out. You didn't object to the mistrial. That's how you get on the record, right? Defense counsel was denied the opportunity to request that the court inquire on which count or counts the jury may have been deadlocked, including lesser offenses, which according to the Supreme Magisterial Court of Massachusetts, whatever it's called, they don't have to. And on which count or counts the jury may have arrived at a verdict. Nor did the court on its own inquire of a jury foreperson on which counts the jury was at an impasse, or whether the jury could or did reach unanimous agreement. According to what we read earlier, they don't like to do that because of bullying behavior and creating bias. Had the court so inquired, it appears clear that a not guilty verdict would have been on 1 and 3. Ms. Reed was denied her right to receive those verdicts in her favor. The foregoing is true and correct to my knowledge. I'll be. They didn't poll the jury because no verdict was written. That's why. Back here, it says, right here, ABA standards relating to trial jury, which allows for less than a unanimous. The requirement that the jury return a verdict slip with a verdict is a change from existing practice. The verdict slip is a written recital of the verdict. The verdict slip will help reduce errors. When a verdict is returned, no verdict was returned. And before the verdict is recorded, the jury may be polled at the discretion of the judge. If the poll there is not unanimous, the jury may redirect and go back for discharge the jury. There was no verdict, so there was nothing for her to poll. The court, when we read further, it says that they're worried about inducing the jury to come up with some sort of verdict when they don't do that. Right here, the subdivision permits a jury in multi-offense cases with the consent of the court to return a verdict at any time during their deliberations with respect to the charges as to which verdict has been reached. If she read that note verbatim, the foreman did not come back and say, hey, we're good on 1 and 3, but we're at an impasse on 2. They didn't say that. What? Law and Crime is now charging to watch that trial. That's okay. Debbie, you may want to check that you're still subscribed and notifications are on. It's very hot. Well, I just read it. Here. Thanks for playing. See it for me. I literally just read it after. It's one thing to say it, see it for me. It's another thing to actually read the source. So I went back to the source. And the judge, at her discretion, is allowed to poll the jury, but she chose not to. Thank you. The foreman said they were deeply divided. I'm not buying it. You don't have to do that, Tennis, but thank you. Why didn't the jury come forward? You live in Canton. Okay, thank you for that. I appreciate it. But if I'm sitting there on a jury and I know very little about law, but I'm sitting on that jury and I know 1 and 3 were good, why didn't anyone object? The jury could have sat there and said, whoa, we have a verdict. Why didn't the jury do that? There is nothing to have stopped any one of those 12 from asking the question to the judge, which they are permitted in Massachusetts, or saying, hey, we got 1 and 3. Why is this foreman out of line here? Now, granted, there would have been a mistrial on that anyway, but why not? You allow you as in the jury, I'm one of 12. I'm allowing everyone to go home. I'm watching the prosecution walk out calmly because that's what they have to do by law. And I'm watching hugs and kisses over there on the defense side. The defense at no time stood up and said, I object to this mistrial. I need it on the record. I object. He didn't do that, did he? He never did it. He didn't say, hey, judge, I object. I would like to know if there was any impasse on 1, 2, or 3. Or was there anything? He's saying the judge should have come out and said it, but in his world, as a defense attorney, Law and Order says, he should have just objected to be on the record, and he never did. He never did it. So jurors speaking up, take you back to November 2023, literally means nothing. The judge has so much sway in this, whether you like it or not, whether you like the outcome or not. It says it right here, Massachusetts.gov. It's the judge's discretion. But we don't even know if that's true. Murder by Meister says the jury agreed she did it, but not on intent. We don't know. We don't even know if that's true. Because once people get on a Zoom with their friends and they're all about the experience, you can't trust them. You can't trust anybody at that point. She doesn't have a ring on, but I don't wear my ring, and I've been married for 21 years. Defiantly awkward breakfasts in the Jackson household. Something tells me that she doesn't cook, or he doesn't cook, so. The new lawyer she got is pricey times 10. Thank God the jurors are speaking up. I'm glad jurors are speaking up for themselves. I think they should have done it while they're sitting in the courtroom, not 10 days later. They won't get paid after the month's mistrial. Nope. They have more chance of the Pope turning to Islam than murder. I would have said that a Pope ago. But with Pope, this one, Jorge Bergoglio, I don't, anything is possible. He's about to take away Latin Mass in 8 days. Anything is possible. He nuked his marriage to the female attorney. I don't know why attorneys married to other attorneys play around. It doesn't seem very smart. You can't even read this. That affidavit says it all to me. Like A talked to B, talked to C, and I knew who B was because B looked like this person. And the intermediary, it wasn't even the actual person. They all have intermediaries except for A. A is the only one who didn't have an intermediary. Come on. July 2nd. It's July 8th. Her lawyer fees, unless she goes to a public defender, won't be covered. That's anywhere. What court, what county, what state, what borough or village is going to cover this defendant's court fees and lawyer fees? They're not. Unless she goes with a public defender. And she has too much money for a public defender. She owns a home. Her daddy owns a home. There's far too much money involved. She may not want to spend it, but financially, Miss Thing will not be qualified for a public defender. So Canton will not be paying for her fees in the end. So you guys are going to vote to pay for this woman's fees. I hope you do it for everybody. I hope you do, because if I were a defendant in Canton, the first thing I would do is sue all y'all and have my fees paid for by the Selectmen. Nuts. That's just nuts. You want to be on the hook for this woman's fees? Good Lord. I mean, with all due respect, ma'am, that is dumb. Because once you Selectmen vote to pay for the fees of Karen Reed, who clearly has enough money to pay for her own fees, Lord knows she's out drinking all the time. She needs to stop the toddies and concentrate on her freedom. That's what she really needs to do. She's a freaking finance doctorate, right? Doesn't she have her PhD in finance? Why would a Selectman even bring that motion to the table to pay this woman's fees? That's dumb. Anytime. Then from then on out, you all have any DUIs, whatever you call them in Massachusetts, tickets, whatever. I would want the Selectmen to pay my fees because she can clearly afford it. Oh my God. You know what? I have to tell you that some people would see this as a insult. There is no one happier in this world to be 57 years old, half gray, than me. Nobody. But thank you. She's not falsely accused. If she was falsely accused, she would have been acquitted on all the charges. She wasn't acquitted on any charges. Did anyone notice that during the trial, AJ and Kara always looked to the right when they looked over to the jury? They always seemed to look at one particular person. Yes, I noticed it. Let's start with that. Murder by Maestro. Didn't know that the jury mostly agreed that KR did it. The only argument among the jury was her intent, hence why her team are scrambling. That is a problem. Because if they can better, which we all know, when there's a retrial, the likelihood of a mistrial or the likelihood of an acquittal is very, 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 very small. Very, very. Like I get 57 varies because she said middle-aged angry woman. I'm not saying I'm not angry. I'm just happy to be middle-aged. I'm not even middle-aged. I'm not living to 114, so I'll take it. I believe there were 2 turtle babies affected by the juror. That's cute. My personal opinion is that intent is the same as a cover-up. She worked hard to hide evidence and cover her tracks. I'm a nurse, and I know that that man could not have frozen to death in the road had someone not run over him. So, cause effect, it's no different than being part of a robbery. Someone is shot 12 miles down the road, but I planned the robbery, but that person died, so now I have the hiccups again. I'm responsible for it. How is that any different? And I think, hopefully, the prosecution will do a better job of, he wouldn't be lying in the road frozen solid if he hadn't been hit by a car. You think she was too drunk to intentionally do anything? She wasn't too drunk to call her dad. She wasn't too drunk to call him 3 times. There is only a poll when there is a verdict. But defense could have asked for that poll. There was nothing to stop Yannetti, the prosecution, Jackson from asking for a poll. Now, they would have been denied, but they could have asked. They aren't even on the record asking. Murder says, wait and see Lally's reply. They will be interesting. It is definitely costing her money, Tenacious. That is one expensive 17 pages of nonsense. You think the Commonwealth has responded saying, go ahead with same charges and retrial. Not confirmed, though. I agree. I think they'll look at it for like 24 hours and then that'll be it. It's still funny. It was funny, Debbie. I love when people say, like, I'm middle-aged, like I'm a boomer, which I'm not. I'm past the boomer age. But I think it's funny when people do that and they're like, oh, that's going to get her. It's not going to get me. I love it. I'm like Cher. Remember when Cher was like, she was on a talk show and she's like, 40 was great. 50 was good, 40 was better, 60 was good, 50 was better. I'm like, since I turned 50, I just love it so much. They've been trying to come up with something. I don't believe that any juror reached out to them, especially after he stared them down. Well, they didn't include the screenshot in the affidavit, but they're going to sign an affidavit. It has to be something. But the Zoom, like there's so much, the Zoom meeting, the time in the Zoom meeting, there's so many more details that they left out that there you go, Kimmick. There you go. Everyone says that. Everyone says this to me. I enjoyed you so much, but, Patty, I can't listen to your bias. Everyone has bias, see it for me, including you. But you live in Canton, which is beautiful, so I'll give you that. Only a unanimous verdict counts. What part of that don't they understand? None of it. Why haven't the jurors signed affidavits? My point. There's so much missing out of this. We think we know who it is by their body type. B and C had an intermediary. This isn't even like, yeah, he's going to take the Latin Mass, girlfriend. Taking the Latin Mass. Yeah, doesn't like two churches. I don't like this Pope. That's just my opinion. I think I'm going to do a whole podcast on Francis. I'm going to be excommunicated. I'm sure I'm on the list. I just do not like him at all. So, I don't like what he's done with McCarrick. I don't like it. So, I'm very sad about my faith right now. Not my faith, but the actual church. Yeah, he's going to take it away on the 16th of July. Thank you. He is. It's just so upsetting. It's so upsetting. I can't believe people give her money either. I can't believe someone would sit here and be like, ask the selectmen. So the town selectmen, did you guys ever watch Bob Newhart? Remember the second Bob Newhart? They had selectmen there. It was hilarious. Remember he had the inn in Connecticut? So funny. We don't have selectmen in Pennsylvania, but we do have boroughs and villages and other stuff. We have, prothonotary. So we don't have like appraisers. We have prothonotary. Everything is different. Yeah, who's the selectman's going to pay? Canton's going to pay her bills, and she's sitting high and mighty on an $800,000 house, and so is her dad. Come on. Celia, for me, thinks that Canton is going to be sued by KR for false arrest because she believes KR is innocent. 100%. She's made a lot of money off that man's death. She does actually care about any of these people who are bending over backwards for her. No, she doesn't. She wouldn't buy any of them a coffee. Oh, you blocked? He's reading her comments. I am. People don't want to admit that they've been duped. No, I call that look good, be right. Everyone wants that. I think that's more an innate feeling among people than even food or water. is look good, be right. In the end, if you ever get into an argument where you're willing to walk away, but the other person isn't, just say to yourself, look good, be right. They need to look good and they need to be right. And once you figure that out, your life is so much simpler and it's so much easier to walk away from a conversation. It's look good, be right. We do it all the time in real estate. And a lot of times it's the agent, not even the other party, like the buyer side or the seller side. It's that agent. And they're like, well, I said it was blue. Oh, I had one where they changed the color. We drive to this house. The photo shows a green yard. It was not a green yard. It was photoshopped yard. There was no yard. It was all treed. The whole entire thing was wooded. You call out the agent, and mind you, I'm not very respectful at that point because you lied. And she's like, absolutely not. How'd she say it? It's enhanced. It's enhanced. Is your license enhanced? Your license must be enhanced because you completely lied in a listing and you misled and you did all that. But in the end, it was look good, be right. She could not figure out that what she did was just absolutely unethical. And that people were wasting their time and money, could be seeing in a different house if they'd known that it was an entirely treed lot. Meanwhile, you eliminate the trees in a Photoshop, it's a mess. So look good, be right. Remember that one. It's just ridiculous. It's not a false accusation. Canton ought to be thanking KR for all the money that's coming into Canton because people are traveling to Canton and announcing Canton. And when people will visit Canton, it is a picturesque little town. It is really cute. That church is just absolutely adorable. I'm not disagreeing with you, Kimmick. Not disagreeing. She says she intentionally hit him plain and simple. I don't think she was too drunk. She wasn't too drunk to call her dad. That's my challenge. I didn't get to go see her. I had tickets to go see her, but I had to give them away. Okay. I don't know what you deleted, but it's still funny, probably. It was probably funny to me, but. The next trial needs to be focused squarely on her guilt, not so much on the defense of the witnesses. It needs to be focused on the actual crime. I think that the prosecution was overwhelmed, as many of you have said. They need to bring in their top person, and they need to hammer in that vehicle and the lenses and the actual was that the best medical people the prosecution could get there? Was that it? Because it was horrible. I'm not a medical expert, and I could have done a much better job. He would not have frozen to death if he had not been hit. That's it. He would not have frozen to death if he had not been hit. I don't like anything the Pope has done, and people giving money are idiots being used for that money for, you're saying, yeah, giving her money. I think this Pope gives me an anxiety attack, and I have such a hard time. I had to Google, we're talking about Pope Francis, whatever. I love the name Francis, so it upsets me. But I had to Google for my own Catholic church how much of the money that you give in your collection or tithe goes to the Vatican, and it's minuscule. So I felt better about that. Because the last thing I want to do is support the Vatican. I don't. Daryl, and my other brother Daryl. The guy who played Daryl, the speaking Daryl, lives in Harrisburg, PA. He lives in my hometown now with his wife. She's from there. Selectmen is so bougie. Well, it's very old. So it's very historical. KR can answer to her maker. Turtle Punk started this whole story going with his bias towards the police. This case became a joke at the O'Keefe's expense. That's where it's so sad. Because there's a family without a son. There's kids without a dad. That's where it's so sad. And she, Charlie gets on, go back to Adelson's, Charlie's on the stand. He wasn't sad that Dan was killed. Like, you could tell by the look on his face. He tried to pretend he was sad that Dan was murdered by him and his murder for hire plot. This girl doesn't even, Charlie trying to like swoon at the gallery and look over at the jury and kind of like warm up the jury and the gallery. This girl doesn't have swoon in her. Like, I don't understand the attraction to Karen Reed at all, because she looks miserable. Maybe because she's so thin, maybe because she has duck lips. I'm not quite sure. But she looks absolutely miserable. I'm shocked that people are paying for her defense. She's a grown woman. Right? I would love to see it. Murder. Can you email me? pattyisfunny@gmail.com. I would love to see it. 600 exhibits. I'd love to see you and Patty on a live doing that. Ooh, we should. I've invited Murder. Oh, the middle-aged. It was funny to me. I don't mind being called a middle-aged angry woman. I don't. I thought the evidence was so clear. Apparently, Julie mostly did too. I thought it was that she would at least get a DUI or whatever it is called these days, right? We don't even know what it's called because they changed the name of everything. She started drinking more when she got back to John's. She can hold her booze. Apparently not. She almost fell off a curb in front of her attorney, and that's probably why he grabbed her boob. It should not have taken that long. This trial, Young Thug's trial, I don't understand why they let all these people, it takes so long. And then the jury's so, not confused, but unsure. You got to go back over everything. Not everything, like that cert thing wasn't even evidence. They didn't know why they couldn't get it. It's just too much. It's too much for the average person. You can't argue with this, people. They don't understand reason. I have to change on my profile because of harassment. It was me. Not anymore. Didn't agree with one person. I know. They'll come at you, bro. They will come at you. Tenacious says, I can't believe how many true crime creators I've unsubscribed from due to this trial. I think I have you, Carl, and Boundless Millennial left. Really? I got to look up this Boundless Millennial. Oh, well, Carl wouldn't put up with it. Not for 1 second. But Carl does think that she won't be convicted. At least that's what I read. Am I wrong? Did Carl... I think he's not saying it yet. I think he has a show coming up where he says it. I asked for notification. Why? Yeah. July 9th. Tonight at 9. Oh, tomorrow night at 9. Why Karen Reed will not be convicted of murder on retrial. But he's not going to put up with nonsense. He's not going to do it. He didn't say she wouldn't be convicted of anything. He's saying she won't be convicted of murder. It's on the 9th. Murder. It's on the 9th. At 9 o'clock. Her insides far outweigh whatever anyone sees in her 98 pounds of destruction. Yeah, she's tiny. I don't know how people that small can hold that much liquor. So a client gave me it was a really nice cigar. It was the only cigar I've had since I started right at Easter time that didn't make me puke on the way home. So I had a cigar on Friday and had a little bit of bourbon, little tiny bit. And I was like, I shouldn't even be driving. So I didn't, because I don't. But it's like, no. Hey, Pepper. Charlie Adelson is lucky he never met KR. Tables turned Charlie. Well, she wasn't his type. He likes them tiny, younger, and Asian. So there you go. Jay says she'd be glad to never hear anything about Karen Reed again. Just go away quietly. But John's family deserves justice. They really do. Karen Reed is a middle-aged angry woman. Doesn't she look it? Good night. She looks so miserable. Fulton County corruption. What a mess. Yeah, Carl's looking on the legal side, and I'm assuming he means charge 1, second degree. And some people have said that they overcharged Karen. That if they hadn't overcharged her, it would have been that. And others have said Roberta Glass. So if whoever's saying let me go to, they only listen to me, Carl, and Boundless. Roberta Glass is also not a free Karen Reed person and looks at it pretty fairly, I think. And Roberta said that she didn't even expect it to go to trial, which is why the defense had nobody to defend. Like, they didn't even really put on a defense. Lowry had to introduce all the witnesses because the defense was going to say all those people worked together to murder J.O. and put him on the lawn. Except that putting on all those witnesses just muddles the witnesses, to me. It just muddles it. And they were so boring. God, there's got to be Betty. Ooh, thank you, Murder. There's got to be better people on, like, in Canton or the state of Massachusetts that he can bring in. It has to be. She looks so gaunt. Roberta Glass is the bomb. Yeah, I think she's fair in her assessments. I mean, she agrees with me, but I think she's fair in her assessments. I got to be on her show once. She was kind enough to have me on. Sunny, who is a regular subscriber, gave her my name, and we talked about Tallahassee and then the Adelson trial. But it was so funny because I responded to Court TV's post about this motion. I thought it was funny anyway. And lady responded to me and she goes, I don't know the Adelson trial. And I'm like, how do you not know the Charlie Adelson trial? So I thought that was funny. I was in one of the pro Karen channels recently, and in the chat they were boasting about false reporting Roberta's channel for Karen coverage. Yeah, I'm sure. It's got to happen all the time. But I like her. I like her show. I like her voice. Her voice is so calming. She has such a melodious, like, great radio voice. She's just good at it. Jenny Benny, I waited a long time and wanted to know all what the hype was. I still shocked by the FKR group. Like, there's that many of them. And TB makes furious. Just seeing his face. Turtle Boy. That you would call yourself Turtle Boy is beyond me. The less the prosecutors focus on the family mob bullcrap, the better. They gave it too much validity by focusing. I agree. I think it needs to be clean cut. Dude, he wouldn't have been on the road from hypothermia or a head injury, which I think they need to get a better doctor on that head injury. I think there's absolutely, if that head injury incapacitated him that much, which clearly it did, and then you have hypothermia, which slows your breathing down, which slows all that stuff, then they need a better medical person on, to me. Oh, I'm sure she'll be on about this. I'm sure she'll be on about this motion. But thanks for coming on with me for such a short notice. That was really nice. Yes, if you could like and subscribe if you haven't subscribed. You don't have to agree with me to subscribe. And I try to highlight everyone's comment, whether they agree with me or not. I have no dog in that fight. Oh, well, thank you. I'm really struggling with this humidity, so thank you very much. Usually you see me at the end of a day on a Sunday, and I've been out and showing homes, but I haven't left the office today. So I got here and just did my work. We have like 4 new listings coming up. I'm going to go see a house for Scott, come up with a price. So I help him come up with a price once he's done his beautifying. And so I'm going to do that, and I have to order a window for my house because it still has a board on it from the tornado. I'm going to go do that. So thank you. Yes, Mama B. It was an awesome chat. I really appreciate y'all. I was ready to talk to myself, but you'll see how blonde my hair really is still. Not all gray, but it's very long. It goes to about here. So thank you all. Have a great one. Enjoy your Monday. It's hard to believe it's Monday. See you soon. Probably tomorrow, Thursday. We'll see how Carl does. Take care, everyone. Bye-bye.